Hello and welcome, everybody. We are going to be starting in just another minute. We have a lot of people who are just now entering from the waiting room. So give us another moment and we'll get going. Thanks. Okay, I think we'll start to get into our program while people are still entering. And first, of course, we have the usual few housekeeping rules. If you notice, all of you have been asked to remain with your microphones off as well as your cameras off. We will be taking questions at the end of the presentation, so please use your chat box, which I will be monitoring during the program. I am very pleased to welcome our presenters today. We have Kathleen Bilderback from Affinity Law Group, Peter Hershon, who is Senior Vice President at Coventry, and Michael Soulis, better known as Mike, from MassMutual. With no further ado, Kathleen, I will turn it over to you.
Thanks, Carol, and welcome everybody to our webinar today. Today we are going to go through a case study. The case study is something that I think Peter and Michael and I see quite a bit in terms of the facts. So without further ado, I think we will roll into the case study. As Carol said, we have left lots of time for questions at the end. If you have a question, please make sure to put it in the chat box. So let's move on to our case study today. So today we're going to talk about a company called Raven Health. Raven Health has two shareholders, Andrew, who's 72 years old, and Brad, who's age 70. Each of them own 50% of Raven Health, Inc., which is structured as an S corporation for tax purposes. Andrew is married to Alicia, who is 67 years old. They have 3 children. Evelyn, who's 40, she's the Senior Vice President of Raven Health, Inc. They have a son, Charles, who's 38, who's a physician, not active in the business. And they have a son, Paul, age 36, who's a public school teacher. Now, Andrew and Alicia have done a great job with planning. They have a total gross estate that's about $13 million. Their estate is heavily invested in real estate. They have some qualified plan money and some taxable investments. In addition, of course, they have the value of 50% of the stock in Raven Health. Many years ago, which is 2010, they executed a revocable trust, a joint revocable trust that leaves all of a deceased spouse's assets to the surviving spouse, then to their children in equal shares, and it is distributed, all the assets are distributed to their children outright. So a little bit different from Andrew and Alicia's story, we have Brad. Brad was formerly married to Estelle. They have 2 adult children, Will and Grace, from whom Brad is estranged. Brad never updated his estate planning documents. So his estate planning documents still leave all of his assets to his ex-wife, Estelle, and then to his children in equal shares. Also, Estelle is still named as his financial and healthcare representative under those old documents. Brad remarried. He's now married to Jessica, who's 62 years old. Jessica has no children and she does not work outside of the home. Now, many of you have seen this in your practices. When Brad got divorced, his assets were divided with Estelle 50-50. In addition, poor Brad has made some very bad investment decisions. So in addition to his 50% stake in Raven Health, he has a home, a 401k, and some taxable investments. But outside of Raven Health, his assets total about $1 million. So Andrew and Brad have a shareholder restriction in place. In other words, a buy-sell agreement. It states that if either shareholder dies or becomes disabled, the company is going to buy the deceased or disabled shareholder's stock for fair market value. The document says that fair market value will be determined by the shareholders on an annual basis. In other words, it's an agreed upon value. Currently, their accountant estimates that the value of the company is about $8 million. Because that was an entity purchase buy-sell agreement, in other words, the company was responsible for purchasing a deceased or disabled shareholder's interest, the company purchased term policies on each of the shareholders. Each term policy has a $5 million face amount. It was purchased not only to fund the buy-sell agreement, but also to provide the company with some key person coverage so that the company could replace the shareholder in terms of job duties at a shareholder's death. So at this point in time, Andrew and Brad are in their early 70s. They've decided it's time to retire and to transition the business to the next generation. That next generation includes Evelyn, who's Andrew and Alicia's oldest child, and two other members of the management team, Dan and Chris. The three of them have been in discussions to acquire the business from Andrew and Brad. Now, Andrew would like to gift his 50% interest to his daughter, Evelyn. Dan and Chris would like to buy Brad's interest in the company, 25% each, and pay with a 10-year promissory note bearing interest at a market rate. All of the parties have agreed to this arrangement. After the after the management succession is executed, obviously the company is not going to have a use for those term policies insuring Andrew and Brad. Andrew and Brad, of course, would like to use those term policies in some way because they don't want the new owners to have a windfall if they die. So let's talk a little bit about where we sit with the client's concerns. First of all, Andrew. Andrew is concerned about Alicia's cash flow in retirement, particularly if something happens to him. And he is concerned about being fair to his other two children. If he gifts the stock in the company to Evelyn, what about his two boys? Brad's concerns are different. He's concerned about the security of those promissory notes from the other two managers if something happens to one of them. In other words, if one of the buyers dies or becomes disabled. Brad's also very concerned about Jessica's long-term care needs. Remember that Jessica has no children, so she doesn't have anybody to rely on if Brad passes away. The management team has their own concerns. They're concerned about what would happen if one of them dies or becomes disabled after the transaction, particularly if there's still that debt out there. And finally, their advisors are concerned about all of the things that they're missing, because frequently we can see things objectively from a 20,000-foot view that the clients can't see. So without further ado, I'm going to turn it over to Peter to talk about how he might have some solutions for Andrew's, Brad's, and the management team's issues. Peter?
Sure. Thank you, Kathleen. All right. So appreciate all of your time here today. What specifically the area that I'm going to address is in regards to the existing two life insurance policies. I'm our Senior Vice President over here at Coventry. I've been with the firm for 19 years. And our area of expertise is in what we refer to as the life settlement marketplace, as we are the largest institutional purchaser in this market. And we see quite a bit of policies that are taken out for buy-sell or key man type purposes when an executive is retiring, where now that company is looking at making a change to that contract as the policy is no longer needed. It's viewed more as a liability on their books due to the premiums associated with it than it is an asset. So as an example, in this case example here, right, Andrew and Brad each took out through the company a $5 million policy for buy, sell, and key man purposes, with the company going along with how the buy, sell, and entity buy, sell agreement is set up, with the company being the owner and beneficiary of each one of these policies. Both were 15-year term policies that at this point in time had about 2 years left on the level term paying period, okay, and still were convertible for the balance of that level premium paying period. Andrew, being a 72-year-old male, when he got this contract 13 years ago, was in perfect health and was issued at preferred rates. Okay, still today is in still relatively good health. Had some concerns, for him, he had separate personal life insurance that was going to satisfy his long-term personal planning needs, but did not feel that this life insurance was something that he was going to need, or frankly, didn't want the company to maintain it while he wasn't there, as well as didn't really have the interest in keeping the policy for himself due to the much larger premium that would be associated with converting this policy over to a permanent contract. Okay, Brad, a little bit of a similar situation, a little bit on the younger side. He's a 70-year-old male, 15-year term, 2 years left. Okay, this policy, Brad was a little bit on the heavier side, had some high cholesterol. So when he went into underwriting 13 years ago, he was at standard rates. Okay, most would think Andrew, being a little bit older, okay, would have a policy that would have more value to it in what we refer to as the life settlement market. The reality is Brad actually had experienced more changes in his health since this policy had been issued. Okay, and his contract was actually worth $942,000 through a life settlement option. Andrew, on the other hand, was still in really good health. Okay, and his policy had significantly less value to it and got an offer of $480,000. So for the two policies below, we're talking a little bit under $1.5 million in value that they were able to create. Okay, I think it's also important to note the agent and their advisor to the company who had originally written them the term policies assisted in this process and was the agent on the conversion of both of these contracts that ended up having a first year premium of roughly $375,000. Okay. One of the major challenges that they had here was that Andrew and Brad kind of had different motivations, right? Brad had a much smaller estate. He was on his second marriage and really had some concern about his wife Jessica's long-term care needs. So what he ended up doing, since Brad and Andrew at the point of sale of these policies still controlled the company, they ended up really distributing most of the assets to themselves. Okay, they felt the company no longer needed these policies and essentially wanted to liquidate them. Brad ended up going out and buying a hybrid long-term care policy on his younger spouse to now have some peace of mind that she was going to be able to be taken care of in the future. Andrew was in a much better financial situation. Okay, that being said, he still had some concerns for Alicia's cash flow, as well as wanted to see what he can do in today's world to help even out the share, since his one daughter was going to be taking over the company. He planned to gift her all of those assets. Okay, in addition to that, wanted to see what he could do to make it up to the two children. So he ended up utilizing large of that to invest for the future benefit of his two children, as well as their soon-to-be grandchildren. Hey, one thing I think is important to note, right, stepping away from this case example a little bit, is we see more and more situations where the life settlement transaction is occurring because people have had changes in their life insurance needs. Just like in this example, where the company's needs have changed, their planning has changed. We see that with companies, individuals all the time. There's 1,000 reasons why people buy life insurance, and there's 1,000 reasons why that need for life insurance might change over time. And we often, for senior clients, see a life settlement utilized as a way for them to essentially reassess their needs, leverage the current value of that policy, not the cash surrender value, and then reallocate the funds to help better accomplish their planning goals. In today's world, we see a lot of situations where it's not necessarily a term policy, it's a permanent life insurance contract. And due to the low interest rate environment that we're in, the client, the policyholder, is essentially being squeezed on two ends. They're being squeezed, number one, because their savings or their fixed income account isn't yielding what it used to, right? Cost of living is going up, but their fixed income investments, their CDs, their saving accounts aren't growing like they had previously had. On the same time, their insurance contracts, specifically universal life policies, are underperforming. The low interest rate environment has had a major toll on those contracts. And we're starting to see more and more consumers and their advisors taking note of that, looking at that annual statement and seeing that despite the fact that the same monthly premium has been paid over the last 15 years since it was first issued, the cash value is no longer increasing. It's now decreasing. Okay, they're looking a little further below in the annual statement, seeing that if you continue to pay this premium, this policy is not going to stay in force to age 100. It's going to lapse in 7 to 8 years. So they're being confronted with the fact that they're going to need to pay more for their life insurance than they originally anticipated. And they're looking for options related to that. In the estate planning world, we also see many situations, right, when policies were taken out many years ago, okay, where the estate landscape was dramatically different from where it is today on the federal level, right? Today, in today's world, husband and wife can exempt roughly $22 million combined. I would be remiss if I didn't say that most of us think that number will drop in the next year or two, okay? But most of the consensus is that families with net worths that are below $10 million, we see a lot of situations where they're questioning the need for that policy that's held in that irrevocable life insurance, where they're questioning the need for it, and the grantor is questioning their desire to continue gifting the money to pay the premiums on that policy. And we're seeing a lot of people look at a cash-based life settlement transaction, but we're also seeing people also looking at what we would qualify as a retained death benefit option, sort of a nice option where they can eliminate all their premium obligations. Trust no longer pays premium. Therefore, the grantor no longer gifts any money to the trust to pay the premiums, but their loved ones will still receive a percentage of the death benefit upon the insured's passing. Okay, and other corporate examples that we've seen, sometimes we also see this retained death benefit option leveraged. Instead of leveraging all cash like Brad and Andrew did, they might look at a hybrid option where it was a percentage of the cash that they would receive today to accomplish their planning goals, but also leave a small portion of the benefit, maybe to remain for the next 5 years, okay, that God forbid something was to happen to them, that the company would still receive a portion of the benefit from the insurance carrier. So there is some flexibility with that type of option. And last and least, we see a lot of opportunities in the market today due to unaddressed longevity risk. Okay, we see many situations, right, where people recognize finally that they are living longer than generations had before them. Unfortunately, they haven't incorporated that whole concept of longevity into their overall financial plan. So we see a lot of situations where the original purpose of the life insurance was wealth transfer to the younger generation. But the focus on the planning today is more on income for today, so they're not a burden on that next generation. Think about it. People are living more years in retirement than they had originally anticipated. To compound the issue, their expenditures are higher due to rising healthcare costs. So we see more and more situations where people are reassessing that need for life insurance, incorporating what their planning goals are today, and then reallocating the funds from the life insurance policy to help better accomplish those goals. So I wanted just to touch base on that. I know I kind of sidestepped to walk away from our case study here, but obviously Andrew and Brad and the company were able to leverage almost $1.5 million worth of value from these two policies that they essentially felt were no longer needed for the company, nor did they want the company to maintain, because they didn't want essentially the new owners to get this huge windfall upon their passing at a later date. Okay, and on that, I'm going to pass this one back to you here, Kathleen.
Peter, thank you so much. I really appreciate that insight. And now I think we're going to actually turn it over to Michael, because I think he has some things to add about the Brad and Andrew situation. Michael?
Can you hear me okay, Kathleen?
I can.
Excellent. Thank you so much. Again, my name is Michael Soulis. I'm the regional manager for MassMutual, covering long-term care solutions in both New York and New Jersey. Been in the industry about 20 years, but first a little background about MassMutual. And as Peter mentioned, hybrid solutions and what MassMutual can do that is completely different than what we see in the marketplace. When we think about why do advisors and clients alike want to partner with MassMutual, we've actually paid the most consistent dividend in US history. We've paid a dividend for 154 consecutive years. That being said, for my history buffs, that's since Andrew Johnson was our 17th president. So given the current situation and economic environment, we paid through the latter end of the Civil War, the Great Depression, Spanish flu, and currently in this time, COVID. We just released this year's dividend, 6%. In fact, last year during COVID was also 6%, so we did not go down. Peter mentioned a few times in his presentation about the low yield environment. When we think about equities and protection from that side, it's been one of the lowest yield environments we've seen in 100 years. Now, what is the MassMutual solution and how can we provide in our hybrid solution a little bit better for the client situation that we have? Brad, Andrew, his wife, Jessica, and Alicia. When we think about planning for long-term care specifically, what MassMutual does that is completely different, we are on a whole life chassis that participates in a dividend. Now, I have to legally tell you that dividends are not guaranteed. However, we have paid them longer, as I mentioned, than any other company in history. A little bit of this dividend, as I mentioned, the 6%, will go to grow the client's long-term care, continue to grow their death benefit, and more importantly, when we're talking about our business professionals in both a buy-sell agreement, we'll also provide access to cash inside of their policy, and it's completely liquid. They can cancel at any time and walk away with the cash. So let me share my screen and just give you a couple of ideas here. Can you see my screen okay? Now, when we take a look at this, I just wanted to express here the annual dividend at 6%. You can see the last 50 years of our dividend. This is one of the lowest dividends we paid in 50 years. In fact, our average dividend over the last 50 has been closer to 7.5. So what I also wanted to do is just bring a little bit of an idea on how particularly we can help Andrew and Brad. Now, I know Peter's solutions cover clients that are a little bit older, but I want to address their spouses, Alicia and Jessica. When we look at younger folks, we can write up to age 70, And this is just an idea. They could put a lump sum in to cover their long-term care protection and business needs. So when we take a look, a client, now this is going to cover also the buyers in this case, Evelyn, Dan, and Chris. We talked a little bit about how if one of them becomes disabled or if they pass away, they want to have protection for their family. And the management is typically concerned what would happen and what are the gaps in their wealth planning, retirement income protection, and their long-term care needs. This we're designed for a little bit younger. Our sweet spot is going to be 45 to say 70 years old. And this is an idea for a 55-year-old client. Typically, we would expect Evelyn, Dan, and Chris to all be within their mid-50s. If you were to place $100,000 in today, that's going to create a day one death benefit of $178,840. Now, with the dividend participation, as I mentioned, that's going to continue to grow. And what we're going to see here is at age 85, there's a couple different considerations when we're looking at the case study. If I did not use long-term care and I didn't access any cash in the policy and I pass away, there's now a $320,000 death benefit that would be paid out to the named beneficiaries. And more importantly, when we look at the long-term care benefit, that also continued to grow. $357,000 it started on day one, and it grew to over $494,000. Now, one of the most important aspects when we talk to people about long-term care that we learned, number one, typically a lot of the solutions in the hybrid space, they don't grow cash, they don't grow a death benefit. So when we look at the value that MassMutual adds, we have an opportunity here to consider flexibility, access, and choice later in life. When you look at the policy surrender value with the dividend participation, we placed $100,000 in day one. Now, at age 85, that's a decision point. As I move older in my long-term care protection, I'm now 85 years old, I could come back to my advisor and say, you know what, I'm 85, I haven't had a long-term care event at this point. I don't think I want the policy. It's more likely I could pass away peacefully in my sleep. And again, we're thinking about businesses. They may need access to their cash, and directions, as Peter said, may have completely changed. I could cancel the policy and MassMutual is going to issue a check for over $264,000. In today's marketplace, you can see here quite readily that represents 3.18% internal rate of return on the cash growth. So again, flexibility in business ownership. Also, when we think about the death benefit, typically hybrids don't grow a death benefit. Here in this case, it grew from 178 to over 320,000, and that represents a 3.83 internal rate of return on the death benefit, more than keeping up with inflationary erosion. And as Peter said, this is likely a lot more than what we see in our fixed instruments, CDs, money markets, even your bond ladder folks. And more importantly, this is a long-term care protection that will cover Evelyn, Dan, and Chris for their long-term care needs. It grew from day one, 357, now at age 85, where we see most of our clients that need long-term care between ages 80 and 90. It's now grown to just short of $500,000, and that represents 4.89% internal rate of return on the long-term care benefit. So the MassMutual difference in the solution will provide growth, access to the cash. Clients can go right in and access cash if their business needs change. And lastly, of course, we offer the same growth in long-term care that a lot of the other hybrids do, but we can offer a lot more choice, flexibility, and access later on in life, depending upon how those business needs change and personal needs change over time. When people in this case study, as we've seen, they've gotten divorced, they get remarried, they have children to take care of. And again, we can name inside of the policy the name beneficiaries to cover the children as well for those that feel it's most important. Thank you.
Michael, thank you so much for bringing your expertise to the facts of our case study. And now it's my turn as a practicing attorney to talk about planning and what I see in this particular fact situation. So we're going to go back to the first slide, the first fact slide. We're going to start there. So we're going to move ahead to, okay, so we have Andrew and Brad, each own 50% of Raven Health, which is an S corporation. Well, a couple things I want to point out just from that first sentence. They own this company 50-50. So under normal valuation rules, there is no majority interest here, which means that if we were valuing Andrew's 50% interest or Brad's 50% interest, either for estate tax purposes or for gift tax purposes, we would be valuing those with a discount because there is no majority interest. So those interests would potentially get minority interest discounts, as well as being an interest in a closely held business, which doesn't have a lot of marketability. Also on the S corporation side, many of you are tracking what's going on in Congress in terms of the changes that are proposed in the legislation. A lot of those changes would hit S corporation owners very hard, particularly high net worth S corporation owners, depending upon how Congress ultimately defines high net worth. But if you have S corporation owners who are single people who make more than $400,000 a year, or married couples that make more than $450,000 a year, you better keep track of what's going on in terms of potential tax law changes at the end of the year. So first we have Andrew and Alicia. They have 3 children. 1 is active in the business, 2 are not. Among the 2 that are not active in the business, we have 1 who is a practicing physician and 1 who's a public school teacher. So we anticipate that there's going to be a disparity there in terms of how much income Charles is going to make over his working life versus Paul. I'm not saying that there's anything that Andrew and Alicia necessarily want to do about that disparity, but for a planner, it's definitely something that we want to make sure that we ask the client about how they feel about it. Is there going to be a disparate distribution? Should Paul ultimately get more on a percentage basis of Andrew and Alicia's estate than Charles? Again, it's not something that they may or may not want to, they may want to move on it or not, but it's definitely something that we want to ask about. Their total gross estate is $13 million. As I believe we heard Peter say mere moments ago, currently the federal estate tax exemption is $11.7 million. So Andrew and Alicia do not have an estate tax problem as we sit today. However, even if the law does not change, at the end of 2025, the federal estate tax exemption drops back to $5 million per spouse indexed for inflation. The proposal that has been winding its way through Congress would accelerate that decrease in the federal estate tax exemption to the end of 2021, meaning that if that tax proposal were passed at the end of 2021, the federal estate tax exemption would drop to $5 million per spouse indexed for inflation. Right now, with the current indexing, it looks like the exemption would end up about $6 million per spouse. If that happens at the end of 2021, or when it happens at the end of 2025 under current law, Andrew and Alicia have an estate tax problem. And remember, when we're looking at that 13 million, we're saying that if the estate tax exemption drops at the end of 2021, they have an estate tax problem. If those assets appreciate between now and when under current law the exemption changes, they could have a bigger estate tax problem. We didn't talk too much about Andrew and Alicia's insurability, but maybe at this point they want to consider a joint survivor life insurance contract in a joint ILET to keep the proceeds out of their estates, either spouse's estate for estate tax purposes, but to provide liquidity to pay estate tax when they're both deceased. Remember that the assets here, it says that they're invested heavily in real estate, an illiquid asset. They also have qualified plan assets. Again, if those are traditional qualified plans, and we had to take the money out of those qualified plans to pay estate taxes, we're going to have to pay a significant chunk of those qualified plan proceeds in income taxes in order to generate the money to pay estate taxes. So it's probably time to start looking at some second to die, because we know under current law, the estate tax exemption is going to change. These clients did what they needed to do back in 2010, and they got their estate planning documents done. The problem is they got them done in 2010, and it appears that they have not updated those documents since then. We've had two major estate tax changes since 2010, one being the 2012 American Taxpayer Relief Act, or ATRA, and the other in 2017 being the Tax Cuts and Jobs Act. In addition, in the interim, we've also had passage of the Secure Act, which changes the way that distributions to non-spouse beneficiaries are made from qualified plans. So, 2010, estate planning documents, time to update. Here at Affinity, we generally recommend that our clients update their estate planning documents every 5 years, even if nothing changes. Here we've had significant estate tax legislation. We've had the Secure Act. They should be updating. Also, their revocable trust leaves all of the assets to the surviving spouse. and then equally to their 3 children and distributes to those children outright. Is that the best plan? That's not the plan I would recommend for them at this point in time. First of all, you know, there's no potential asset protection there for the surviving spouse, because if all the assets are left to a survivor's trust, let's say, for the surviving spouse has full access over that trust. Those assets could potentially be accessed by the surviving spouse's creditors. Where one spouse or both spouses are business owners or attorneys or physicians, we generally make sure that we talk about asset protection and that there's asset protection built into the plan. Also, for estate tax purposes, are they okay here with everything passing to the spouse? Potentially. Remember that we now have portability of the estate tax exemption. So if one spouse dies, doesn't use their full estate tax exemption, by filing a simplified 706, the surviving spouse can carry that deceased spouse's exemption forward. But there are steps that need to be taken in order to do that. It's not automatic. Finally, what do I see here in leaving assets outright to children? They are subject to all kinds of potential creditor claims. Ex-spouses. Evelyn's going to be a business owner herself. If something goes wrong with the business, if she has those assets in her own name, they are potentially accessible by her creditors. What would be a better solution? Perhaps dividing the assets and leaving them to the children in trust. In a beneficiary controlled trust model, the child can be trustee of their own trust. And as long as the child can only make distributions to themselves under that ascertainable standard of health, education, maintenance, and support, under current law in most states, those assets are still protected from the child's creditors. So maybe we're looking at a beneficiary controlled trust for the child, sometimes referred to as a life trust rather than an outright distribution. So on a scale of 1 to 10, I would say Andrew and Alicia are at a 7 in terms of their estate planning. They did the estate planning, they have something in place, but it's not as good as it could be. They need an update. So let's move on now and talk a little bit about poor Brad. So Brad's been married before. Brad was married to Estelle. They have 2 adult children. Brad doesn't talk to his adult children anymore. Yet his old will says that if he dies, everything passes to his ex-wife, and if his ex-wife is not living, then to his children from whom he's estranged in equal shares. So let's talk first about the divorce. In most states, divorce would cut off the surviving spouse's ability to be a beneficiary under a will, or to serve in any kind of representative capacity. However, that's not necessarily true everywhere. If you are working in more than one state, you need to make sure, if your client is going through a divorce, what the rules are. Typically, there are rules that affect the will, the powers of attorney, and potentially qualified plan proceeds. But I'll tell you where it gets a little bit hairy is with life insurance. We had a case a few years ago. Basically, client and spouse got divorced in February. Client was much older. It was his second wife. He had children from a first marriage, and he had a child with the second wife. He had, among other assets, a $2 million life insurance policy, the beneficiary of which was his revocable trust. Now, I'm sure the ex-spouse was probably not too concerned about how everything was going to shake out because she was a beneficiary under the trust. So were the children from the first marriage, as well as her daughter with him from the second marriage. Unfortunately, she didn't read the fine print in the back of the trust that said if the couple got divorced, the spouse would no longer be a beneficiary of the trust and could no longer serve as trustee. So when he died, none of the assets had been divided according to the divorce decree. They were divorced, let's see, in February. He died in December. Nothing had been transferred. That's something you really have to watch out for. She was no longer a beneficiary of the trust, and she was no longer a trustee. So we went into litigation about that $2 million policy and how to divvy it up between the children from the first marriage, the ex-wife, and the child from the second marriage. It was nasty litigation. We ended up settling. It could have all been avoided if the beneficiary designations on the policy had been checked at the time of the divorce and changed appropriately. So here we've got Brad. He really needs to go back, get some new estate planning documents. In most states, if he doesn't want to leave anything to Will and Grace, he needs to explicitly state that in his documents, that he is disinheriting them. If he wants to leave everything to Jessica. I'm not saying that he does. It's not fully fleshed out in the facts, but that's something that we want to discuss. Brad here doesn't have a lot of money, which I think is where Peter and Michael's suggestions can really come into play, particularly Peter. We need to do something for Jessica because she has no children to take care of her if she has long-term care needs in the future. So then moving on, not only do we have all of these estate planning issues, but we also have the succession planning issues. So they've decided it's time to retire and the management team is going to buy their interest. Andrew wants to gift his 50% interest to Evelyn, but he's worried about taking away an income stream from Alicia, and he's worried about being fair to his surviving children. Again, there are lots of options here. First of all, Andrew at this point has plenty of exemption to gift, assuming that first of all, there would be a discount on that gift, right? Again, it's a minority interest, a non-controlling interest in a closely held business. So Andrew has plenty of exemption to make that gift to Evelyn. That's not a concern. I will tell you, we are doing a lot of year-end planning right now based on the potential for estate tax changes. In certain cases, historically, husband and wife, if they're married, they split their gifts. Much of the time now, we're advising clients not to split gifts. So in this case, we may want Andrew and Alicia not to split the gift because we would be using up Andrew's exemption, but Alicia's exemption would remain intact. So again, with year-end gifting, if your clients are doing that, it may be a little bit different than what we've seen historically in the past. So he has plenty of ability to gift that 50% interest to Evelyn. What's he going to do to equalize for the boys? Life insurance is a great option. There is a $13 million estate here, of which $4 million is the undiscounted value of his 50% interest in the company. He and Alicia may want to put provisions in their estate planning documents that this gift to Evelyn would come off her ultimate share of all of the assets. So there are ways to deal with that. Dan and Chris here are buying Brad's interest. They're each buying 25%. They're going to pay with a 10-year promissory note, bearing interest at a market rate. One question I get a lot is, what is a market rate? Frequently, that is based on some percentage over prime. Right now, we're seeing a lot of deals being done. I should mention Affinity has a very robust mergers and acquisition practice. We're also doing a lot of year-end intra-family transactions. With the intra-family transactions, typically we're trying to get the interest rate as low as possible. So we're using the applicable federal rate. Here, where it's a non-family transaction, we'd probably be using a few points over prime. Prime is currently about 3.25%. So maybe a 6.25% interest rate on that note. The other thing I wanted to point out from a year-end planning perspective, most of you know promissory notes. Normally they are taxed under Section 453, and the business owner who receives the promissory note, in this case Brad, would be taxed as payments are received. You can opt out of the installment sale treatment of Section 453. So I do have some business owner clients who are planning on selling, and if the tax rates change, so if they go up on a go-forward basis, they may opt out of the installment sale rules so that they would be taxed all in 2021 at a lower rate. Here we have the management team buying the company. Whenever we have a company moving to a different set of shareholders, we always insist that there be an update, a new shareholder restriction agreement. We would want Evelyn and Dan and Chris to be responsible to each other. If something happened to one of them, what's going to happen to their stock in the company? Peter and Michael did a great job covering about the policies that are currently in the company. Obviously, with Evelyn, Dan, and Chris, if we're going to finance that buy-sell shareholder restriction agreement with life insurance, we're going to need new policies on the three of them. We talked a little bit about all of the concerns. I think Peter and Michael did a great job, particularly covering security for surviving spouses and surviving spouses' long-term care needs. The note, Brad is concerned about the security of the note. Frequently, we do have the purchasers who are giving a promissory note sign personal guarantees. But you know, if a client who's a seller has a personal guarantee of the buyer, they still have to enforce that guarantee. A better solution here might be for the term of the promissory note, 10 years, Brad could have a life insurance, term life insurance policy on Dan and on Chris, that if they passed away during that 10-year period that the note was in play, Brad would be made whole via a term life insurance contract. So I think we've pretty much covered their concerns. I know that we left some time for questions. So Carol, can you tell us, are there any questions in the queue?
Well, I have to say, I think we wowed our attendees. They are very anxious, obviously, to have the slides and the recording. I think this particular session took planning for long-term care needs, using life insurance, whether we are repositioning, as Peter suggested, whether we are using a whole life policy that can be used to cover some of the long-term care needs, or whether in fact, I think we saw that in all of these situations where you have business owners, if in fact they're going to have life insurance, I'm sure all of us are aware that if they have a long-term care need and it takes them out of the planning that is being done, you do have to go back to, say, someone like Kathleen and say, okay, we did a good job with this, and now all of a sudden we have a situation where the owner didn't get to retire. He ran into a health situation. So I have to say that this was a very unique and obviously well-received session. Shall I just say, we didn't rehash a lot of things that are normally addressed in long-term care. We tried to say, we're wrapping up our Power Hour week. We do have a nice compliment from one of the attendees. They said, great case study, appreciate the input. Well, me too. As a specialist in the industry, it was wonderful to hear different ways to approach ensuring life and health as we take a new look. And as the government's getting involved, as more financial planners, as investment people are getting involved, I think it was a very refreshing and well-received session. And so, of course, we have just a few minutes left, but instead of questions, I'm getting compliments in the chat box. Very meaningful, since the attendee, Julia, works with small businesses. This was a wonderful information. And of course, we got special strategy ideas. And I think that's significant. You're wrapping up a week where we have done nothing but talk about long-term care. So I think we'll give our attendees and you 5 minutes back, because I think we are about 5 minutes to the hour. But I want to thank you for a very refreshing, informative, a different approach to what I often think people don't think about whole life or repositioning life policies, or really what can my estate planner do to open my eyes before I wind up with a situation that is far more taxing. And I mean the word taxing is a pun, more taxing than it need be. So with that, we end our long-term care awareness impact week. And I want to thank the three of you for a wonderful session and wish everybody a very happy and healthy Thanksgiving and a good weekend to come. Thank you.
Thanks, Carol.
Thanks,
Bye.
Carol.